lose your job commute bill. And he seemed to disagree with you.
Well, that's a first.
That is, is it your view that companies could still fire employees?
I'm glad you brought that up. I wasn't even going to if you all didn't. But last week we talked about this, and I did some research and had my legal staff do research, and I was exactly correct on this last time. Yes, we're in an at-will state, but you can call somebody in and sit them down in a chair and say your services are no longer needed. That's all you have to say. You can say our company is taking a different direction. But if you were to say that the reason you fired somebody is because they had a gun, their firearm in their car, that you can't do that. This is by case law. And actually, Karen Garrett gave me this. In Tennessee, an at-will employee generally may not be discharged for attempting to exercise a statutory or constitutional right or any other reason which violates a clear public policy which is evidenced by an unambiguous constitutional, statutory, or regulatory provision. So we're an at-will state, but you can't fire somebody because of something that is statutorily legal, if that's the only reason you're firing them. Now, don't get me wrong, you can call somebody in and that be the reason you fire them, but you do that tomorrow. And I'll tell you what I'm really against is setting up protected classes of employees. What's the next step? Where do we go then? And I want us to keep us an at-will state, and we are an at-will state. And so we just have the bill that in Education Committee that's debated for hours, for 2 weeks in a row, that attempts to get away from setting up protected classes, and then John Harris and others want to set up a protected class. I'm just against that.
The legislative attorney in committee, in the House committee yesterday, said as an example of a company could ban drinking on the job, even though it's legal to drink if you're over 21. So you could be fired for violating company policy, which is no drinking on the job, and in the same way you can be fired for a company policy saying no guns in parking lots.
I just have a feeling that if somebody used that as an excuse for the reason they let that go, the company would be, there would be a lawsuit filed in court and the company would lose. I don't know. I'm not an attorney. I can't give ever what if or whereas or whatever. But I know this right here is pretty clear too. That case law will say that you can't be discharged for attempting to exercise a statutory constitutional right or statutory or constitutional right. So there's a little difference than drinking on the job and having a firearm stored in your vehicle. That's a little bit different. You can put your fellow workers at danger in the building. You could, I don't have to explain what that would do. And so I think there's a huge difference that the legal system would look at for drinking on the job as opposed to keeping a gun stored in your car.
Well, it sounds like you're just advising businesses basically that if they want to fire an employee who had a gun in his car, they just fire him and don't tell him why.
I don't have to advise anybody that. Any HR person in the state of Tennessee knows that. I've had to dismiss people in my life at my business. I've had to dismiss people here at the legislature. And all you do is say your services are no longer needed. Don't get into anything other than that or you're opening yourself up for a lawsuit. That's in my private business. That's here when things have happened. You sit them down in a chair and say your services are no longer needed. Let me assure you, Ron Ramsey just didn't shed a light on something. Every HR person in the state of Tennessee knows that.
Well, as a practical matter, if the car is kept from ordinary observation or whatever is the bill requires, if the gun is kept from ordinary, how would an employer ever know anyway?
Good question.
I mean, unless somebody went and got the gun.
That's the reason we're what if and this to death, and I think we've written a bill that is as plain and common sense as you can possibly be. That if you're a single mother and taking a class at Northeast State, decide you're coming home at 10 o'clock at night, and you feel like that, look, I'm worried about my car breaking down, I'm worried about the neighborhood I'm driving through, so you go take a class, and you prove your proficiency with the firearms, you put your fingerprints on file with the FBI, you do a background check, you pay the people $150, then and only then you can keep it stored in your car when you drive to work. If we take that right away, as we have, then why even get a gun carry permit? Once again, hallelujah, this passes the House in 2 weeks, and we're talking about something else.
But is it your opinion that you could search? I mean, could a company search your car?
No, they can't search your car without your permission. No, that's a constitutional right. You have the same protection on your car as you do your home. Illegal search and seizure. No.
But could they put as a precondition of employment that by
Yes,
coming to work here you agree to?
Yeah, but then they couldn't fire them because they had a firearm in there because that's statutorily legal.
Mm-hmm.
Now, if they find drugs in there, that's statutory illegal. So therefore, they could fire them.
What case is that? Does it say on
That doesn't. I'll find out for you though. This is from a employer law, whatever. I can find out.
And this is from one of the
Legislative legal staff.
I heard that you spoke to private